at this stage. Both Sean and Mary have promised that I'm going to talk about various things along the way. I hope I don't disappoint you now, but anyway, I'm due to finish in about 10 minutes according to the schedule, which would suit me, but I'll take a little bit longer perhaps. Having moved from directives that are on their way towards us and are going to be transposed over the next 12 months or 24 months, I'm going to take you to a directive that's very recently transposed, just this summer gone. And I'm going to talk about B2C, business to consumer online transactions, and what has changed in particular since the summer. So just to be clear on what was then and what is now, before this summer, we had a directive called the Distance Selling Directive, adopted back in 1997, transposed in Ireland in 2001, which dealt with distance contracts, including online contracts. However, since the 14th of June 2014, that directive and those regulations have been revoked or repealed, and we have in their place, and it's been mentioned a couple of times along the way, the Consumer Rights Directive, adopted back in 2011, but only transposed with us since the summer just gone. The regulations were published pre-Christmas, Christmas 2013, brought into effect summer 2014. They're transposed in Ireland in two sets of regulations. There, 484 is the main set of regulations. The second set of regulations had to be introduced to deal with a minor issue around commencement and wording, to kind of plug a gap or an uncertainty in the commencement of the provisions. So the main regulations are these 484 regulations, statutory instrument number 484. And the Consumer Rights Directive itself held great promise to begin with. Mary has mentioned this. It was supposed to coordinate and reorganise and bring together a number of different directives and modernise them. In the end, it was something a little less, but it still covers a broad range of transactions. So it applies to what we call on-premises sales, when you buy something, if you like, face-to-face in the shop. Off-premises sales, what we used to call doorstep selling. And also distance contracts, which is where I'm going to focus its application to distance contracts, and in particular online distance contracts. So that's my particular focus. And just to focus your mind a little bit, online selling is a big thing now, and there's lots of good reasons why people buy online and not in the premises, not least because of the comfort of being able to shop from home and the risks of having to go out in your underwear when the network breaks down. From a consumer perspective, of course, you have this vast market available to you from home, and you know, if you put time and effort in, you have competitive prices. There are risks, of course, with distance selling, but generally speaking, it offers consumers a huge amount if you can convince them to engage with it. And of course, it offers businesses another platform on which to sell. Online selling has been growing and growing. Just to show you some figures and some aspirations, I suppose, about this market, there is an EU digital agenda. These are aspirations in terms of the growth of this digital market and this digital economy. And I've just pulled a few targets from that digital agenda. It's a vast document, if you like. By 2015, this is again the European Commission driving this agenda. For example, the aspiration or the target is that 33% of SMEs in Europe will be selling online. As of 2012, only 14% of SMEs have an online presence. So there's a huge potential for growth there, at least the Commission believes. Okay. Just another few figures. They also hope by 2015 that 20% of the European population will be buying cross-border. Again, a relatively disappointing figure. By 2012, only 12% of the average European population, if you like, the cross-European population, were buying cross-border in the single market that we've had operating since 1957, or we've been participating in since 1973. The cross-border selling is still something that in general Europeans aren't good at. I'll show you a figure in a moment about the Irish. We're a bit better. And then a third target is that by 2015 the Commission were wanting 50% of the population buying online. We've actually reached that target in the last year or so. So that one they've achieved. But my point is, this is a market that still has huge potential in terms of serving the consumers within Europe and providing an outlet for businesses. And for practitioners here who have business clients whose business it is to sell, are they utilising all these platforms to their best advantage? It's an important question to raise. Just a few more figures. If we go back just 10 years, this is just to show how rapidly things can change. Just 10 years ago, when EU citizens were surveyed, back at the time the survey was conducted when there were only 15 member states, at that time only 16% of the population had bought something on the internet in the previous 12 months. That's only 10 years ago. Go right up to last year, which is the most recent figures we can find. By 2013, purchases via the internet across the EU 27 were up to 53%. So just over half the EU population are buying online. But clearly, again, there's room for that to grow. In Ireland, we're better than the EU average. The Irish figure is 66% of this population buy online. And when you kind of dig into these figures, again, you can see by 2013, the cross-border figure, which I think was 12% on my last slide, has gone up to 15% across Europe. But in Ireland, we completely bucked the trend. In Ireland, 48% of people buy cross-border. Okay? Nearly half the population, which is, again, a very distinctive feature of the Irish market. Now, that's great for Irish consumers in a sense, in that they have this vast market that they can access. But it is potentially lost sales for Irish businesses because these consumers are shopping somewhere else. And there definitely is a gap in the Irish market that needs to be addressed and needs to be filled. So Irish businesses need to be conscious, I suppose, of the rules in which this market operates and the regulatory environment in which they operate. So that's what brings us back to these regulations 484. And what I want to do in about 15 minutes or thereabouts is just take you through, in outline, I suppose, the nature of these rules and regulations. Again, there's a paper in your bundle that does this in a lot more detail. So just in terms of what's new about these regulations, a few points to make. They are particularly focused on e-commerce and m-commerce activity. The previous regulations were quite silent on these issues. The previous directive, in fact, was really pre the internet. It was drafted before the internet as we know it today. It was drafted back in the early 90s. So it was definitely showing its age. These new regulations focus in particular not just on distance selling, so over the phone, over the television, but over the internet, over mobile networks and other distance forms. Also important in terms of what's new is the scope or the application of these regulations, and in particular, in comparison with the old ones, these regulations specifically apply to the sale and supply of digital content. And I'll show you how that works in a moment. But again, the old regulations were silent on this point. And so in its application to digital content, these regulations are very important, very new. The protections afforded to consumers come in two main forms. And again, you've heard this from Sean in terms of informing consumers. A lot of requirements on traders to provide all sorts of information at different times. In essence, there's more obligations than there used to be, and those obligations are, again, more focused on e-commerce activity, so I'll take you through those. And then the second big protection mechanism in these regulations is the cancellation right, which, again, has been mentioned a number of times. Here, there's been an increase in the cancellation period up to 14 days, and the legislation includes model instructions on cancellation, model forms on how to cancel, and again, a lot more detail on the mechanics of cancellation, which brings clarity for consumers and traders around this whole issue. There are a number of miscellaneous provisions. I'm not sure we'll get to those. So to begin, it's very important that as a consumer, if you're looking for this protection, or as a business, if you're selling at a distance or engaging with consumers, it's very important you know whether these regulations apply to you or not. And there's kind of three stages you need to think of, lots of threes. Three things you need to think of in terms of application. First of all, you must fit within a definition of a distance contract from the legislation. And again, three, isn't this spooky? Three elements to a distance contract. Very simply, the contract must be between a trader, we now use this phrase, trader, and a consumer must be a natural person, so B2C. That's, you know, easy enough to identify most of the time. There can be issues. Secondly, the contract must be concluded under an organised distance sale or service provision scheme. So, for example, if you're in business and an old customer or a good customer of you telephones you and said, by the way, can you, you know, put something aside for me, I'll pick it up later and pay you, and to generate goodwill, you say yes and you put the phone down, that wouldn't be a distance contract more than likely within the terms of these regulations. It would be a once-off, ad hoc contract. It doesn't have an organised feel to it. So when you take the odd order by email or by phone, it doesn't bring you within the scheme. But if you run a website selling, or if any other platform selling goods or services, it will bring you within the scope of the regulation. So you must be organised in how you conclude your contracts. And then thirdly, the requirement is that for something to be a distance contract, and this is obvious in one sense, it must be concluded without the simultaneous physical presence of the trader and the consumer. They must be at a distance, not face to face. And as well as that, they need to exclusively use one or more means of distance communication up to and including the time the contract is concluded. So telephones, television, mobile phones, the internet, catalogues, mail order, they're all forms of distance contracts. So that's the first thing you must be involved in, a distance contract. The regulations then identify 5 particular contract types that you must fall within. And these include what you might expect: contracts for the sale of goods, contracts for the supply of services. That was always the case. But what is new is in the definition of sale of goods contracts is now included digital content which is supplied on a tangible medium, amongst other things. And so, for example, if you buy a CD with music on it or a DVD with a film on it, you are buying something in a tangible form, but what you were really buying is the digital content to listen to it or view it later. That's classified as goods, and that clarifies, I suppose, a point which the previous regulations didn't address at all. And then thirdly, to catch all that other digital content that we listen to and view all the time, also expressly included in these regs now are digital content not supplied on a tangible medium. So that intangible digital content that we download or we stream or we access in other forms. And then the remaining contracts are kind of utility type contracts, electricity, gas, heating, which again aren't relevant to my talk today. The third feature of application, so it has to be a distance contract, it must be one of these 5, is even if you come within both of those requirements, there are then exemptions. So certain contracts are exempted from the scope of these regulations. And this is again very important. A lot of these exemptions exist because there is other regulation, more specific regulation. So it's not that you're off the hook, you just fall under another directive if you're a trader, or if you're a consumer, you can get your protection elsewhere. Some of the other exemptions are there because it's an area of law the European Union doesn't as yet show an interest in. So there are 14 different contracts types listed in the regulations, and they're listed in my paper. So, for example, just to give you a few, financial services don't come under this directive because there's a financial services, distance marketing and financial services directive already out there. Same with package holidays, timeshare, there are European measures directly focused on those. Immovable property, the construction of new buildings, again, that's that bit of land law that the EU tends not to interfere too much with. It's better regulated at a domestic level. So 14 contracts types excluded. If the regulations still apply to you after all of this, then you're into the main forms of protections. And the first of these, I should say there's a partial exemption, for passenger transport services. Some of the provisions apply to passenger transport services, the information provisions, others don't, the cancellation provisions don't. If you are within the scope of the regulations, then one of the 2 main things you have to do as a business is you must provide certain information to consumers. And just very quickly, the whole idea here is that when consumers buy at a distance or online, the understanding is they buy or they suffer from what we'd call an information deficit. Okay, so instead of being in the shop, talking to the seller, looking at the goods, touching them, feeling them, examining them, trying them on or switching them on and off. You're doing all this looking at a screen, for example, and you're not quite sure who you're dealing with. And so the idea is to meet that information deficit and to encourage consumers to engage in this market, because the figures are still poor and we've been at this for a while. Consumers must be given information in advance, in the middle and at the end, in fact, an awful lot of information, so that they are confident consumers and that they engage in the market and the market grows. That's the rationale. Again, in terms of information obligations, 3 things to think about. There are general pre-contract information obligations. I'll show you them in a moment. Then there are post-contract information obligations, moving to the final bullet point here. So before the contract is formed, you have to provide a swathe of information. After the contract, if ever, is formed, you have to provide another volume of information. And in between, and what's very new, are specific information provisions in relation to m-commerce, website and e-commerce. Okay. So this does lend to the concept of information overload and questions about how much we read the terms and conditions, but that's for another day. In terms of the pre-contract, the general pre-contract information requirements, here we go again. What, when and how, 3. What do you have to provide? In Schedule 2 to the regulations, there are 24 items of information, and this is a big increase on what used to be there. But just to show you, some of this would be up there anyway, you know. I mean, if you're selling goods, clearly you're going to describe them, and services, you're going to try and paint them in the best picture possible. So information about the main characteristics of the goods and services, the identity of the trader, his trading name, contact details, geographical address, telephone number, fax number, email, every which way you can contact him or her, all of that has to be included. Total price, that's including taxes, additional costs, arrangements for payment, and if there is a cancellation right, you must tell them about it up front. So these are some of the 24 items, but in particular in terms of what's new, very important for digital content. It is now a requirement if you're selling digital content that you provide information about the functionality of that digital content, what kind of a file it is, the size of the file, the duration of the file, languages, other features of how it operates, and the interoperability of that digital content, how it interacts with other software or hardware, whether you need a particular operating system, whether you need a particular version of an operating system. All of this has to be disclosed in advance, if you like, on the website. And that's, there is more. Also new is you must make, if there is a cancellation right, you must make available this model cancellation form, which is set out in Schedule 3. I'll show it to you in a moment. But again, you're trying to, I suppose, inform the consumer of all the possibilities in terms of entering this transaction. When must all this information be provided? Prior to the contract being formed. And then how? The legislation says it must be provided in a clear and comprehensible manner, in a way appropriate to the means of distance communication used. So again, if you're selling on a website, you put all this on your website. Okay, so About Us has all the information about the trader. Okay, returns policy has all the cancellation stuff with the form. You know, frequently asked questions or other such features, links. It has to be well designed. So the trader and their website designers and the lawyers need to work together on complying with all of these obligations and avoiding what they call dark patterns, ways of kind of sneaking around these obligations and kind of pushing them to their limit. The particular provisions on m-commerce, websites and e-commerce, just to show you, these are new. Regulation 10.7 modifies these information obligations. It lessens them in certain circumstances where, for example, you are using a form of technology which has certain constraints, physical constraints, like a mobile phone screen, which, you know, once upon a time used to be tiny but is getting bigger and bigger. But it is hard to communicate that volume of information on a mobile phone screen, and so in those circumstances, the legislation identifies certain key information that must be available on the mobile phone, and then the rest of the information can be made available or provided in another appropriate means, such as by hyperlink. Okay, so you don't have to try and squeeze all of that information in because of these technical restrictions or time restrictions, if it was television slots or something like that, for example. In relation to a website, if you're selling goods or services over on a website. That website must indicate any delivery restrictions. If you're based in Ireland and you'll only deliver in Ireland, you must make clear you'll only do deliveries in Ireland or wherever. And payment means accepted. Will you accept debit cards, credit cards, PayPal, other mechanisms? All of that must be clear right before the start so that the consumer doesn't waste their time, I suppose, on the site and be disappointed and then be turned off this whole thing. And again, particular requirements in relation to e-commerce contracts. I'll just refer to the final bullet point here. I mean, there is a requirement, a particular provision in the legislation, which talks about concluding a contract which involves a payment obligation via a button, okay? And the requirement that that button or tab should clearly state that not only are you entering into a contract, but you're entering into a payment obligation, okay? And so it requires those buttons that used to say order or register to actually say order and pay, or order with obligation to pay. I'm not sure order and pay is probably the shortest way I can think of satisfying this requirement, but register and pay. But so that there is this danger with one-click ordering, that people just press the button and then there's no going back. They've ordered the thing and they've entered into a payment obligation. So the legislation is that specific that it requires these buttons or these indicators to be clearly labelled. Post-contract information. Again, what, when and how, all that Schedule 2 information again, if it already hasn't been provided in an appropriate way. When this confirmation must occur or be provided within a reasonable time after the conclusion of the contract, and at the latest when the goods are delivered, or if it's in relation to a service before the performance begins. So very specific rules about when this confirmation must be provided. This information that the contract now exists is to be provided. And most significantly, perhaps, it has been debated, but it's very clear now, this post-contract confirmation must come in what they call a durable medium, which means it must come either in paper form or in an email, but not on the internet. Okay, on the basis that the internet is changeable or movable and not durable, this information must be provided on paper or by email. So that's the information obligations. Then the other big protection is the cancellation right. And this is very significant, I suppose, for businesses. This can cause a real headache for businesses. They can't avoid it, of course, if you come within the scope of the regulations, but this comes at a cost, because every time something is returned, it has to be checked, if it's still suitable for resale, repackaged, and it has to be accounted for. And there's, data out there about the cost of returned, what the cost of returned items to business, how much it costs business, and of course that will add to the bottom line price of goods in the long run. So this isn't a win-all situation. The more returns there are, the more this will be reflected in the overall cost. And there are reports from some retailers, I don't know, who would claim some of the goods they sell, up to half of what they sell gets returned. I have read. So I don't know what the cancellation right or the return rate is like, but you do hear these stories about people ordering frocks on a Friday and having a party, trying them all on and sending them back on the Monday morning. Hope nobody has spilt any red wine on it or whatever, or I don't think it's possible. Could you buy a book on Amazon, read it very carefully and return it? So it comes at a cost, but clearly, again, from the consumer's perspective, the fact that you can't touch or feel this stuff before you buy it, the cancellation right is all about getting the goods in particular to you, allowing you to see them, check them the way you would in a shop, and then if you don't like them, if you change your mind, you get to return them. So just in outline, the period for returning goods, which from a business perspective has to mean is, are more goods going to be returned? I don't know, because the period has increased. It's up to now 14 calendar days. It used to be 7 working days in Ireland, so it's not that it quite doubled, but it's 14 calendar days, in line with a lot of other directives in the kind of a 14-day cancellation period. The cancellation is, you don't have to give any reason, you can't be penalised for cancelling. You may incur some costs, including the cost of returning the goods, that can be a feature. But other than that kind of a cost, and you don't necessarily always, the supplier might cover that cost, you are entitled to return the goods for no reason, just change your mind. You just don't like them anymore and get your money back. There are exemptions from the cancellation right. I'll show them some of you show you some of them in a moment, the newer ones. Again, cancellation is detailed in a lot greater form in these regulations, in that there's instructions that a trader can just put these instructions, out of the regulations right up on their website and explain how the whole thing works, and use this standard form. Helps everyone understand what's going on. And a lot more rules on what the trader has to do on cancellation and what the consumer has to do on cancellation. So let me, wait until I see, just show you these two new features of the exemptions to the cancellation right. Again, there are 15 exemptions in all, many of them taken from the Distance Selling Directive, but a couple of the newer ones, and this is a significant change. In relation to service contracts under the old rules, once the service commenced, you lost your right to cancel it. Okay? Whereas now you only lose your right to cancel in relation to a service contract after it has been fully performed, and then only if the performance was begun with the consumer's prior consent and with the consumer's acknowledgement of the loss of the right. So you can actually commence the performance of a service, and mid-performance it can be cancelled. A proportionate amount will have to be paid under the rules relative to the total price payable. But it does extend the cancellation right for consumers, and a similar approach, a particular provision then in relation to digital content, again, where you're downloading and streaming. There you can't cancel where performance has begun. So once you start streaming, you can't cancel. But that streaming must begin with the consumer's prior consent and the consumer's acknowledgement. And if you don't have either of those, they can cancel. Okay? So new rules around cancellation. That's the model cancellation form. It's quite short. It's easy to follow, with kind of blanks to be filled in by the parties to facilitate cancellation. And just take you through these two last slides, and I'll finish there. There are further details in the paper. In terms of duties on cancellation, for the trader, you have to return payments, and you have to do so within 14 days of being informed of the cancellation decision. But importantly, and new since the summer, you must refund using the same payment method. So if a consumer buys using the credit card, the repayment must go back on their credit card and not any other inconvenient means of repayment. And also new, on the trader's side, a trader can withhold refund until the goods are actually returned to him, or he has evidence that the goods are on their way back. Last slide. On the consumer side, the consumer must return the goods unless the trader's agreed to collect them. And again, lots of traders will carry that cost. They'll agree, free delivery or free returns. It's a choice traders have to make. Again, within 14 days, the goods must be returned. The return typically is at the consumer's cost unless the trader offers to carry that cost. And in two new provisions, consumers now must take reasonable care of the goods while they're in their possession, and also may be liable for any diminished value to those goods while they're in their possession if they use them more than would be acceptable to kind of just try and test them out. Okay, so a lot more detail around cancellation rights for consumers. Let me show you. There's oops, gone too far. There's an enforcement slide there. Sean has talked about enforcement. But on these regulations, there are, as well as the paper in your folder, there are guidance notes provided by our own Department of Jobs, Innovation and Enterprise, and by DG Justice, which look in great detail at particular provisions and offer guidance as to how those provisions would be interpreted. Ultimately, it'll be up to a court, I suppose, to decide what they mean for both traders and consumers. So I better finish there, as the time is really flying ahead.